Thank you very much, Mette Gjerskov. I now introduce Laila Hanafi for the first keynote speech. Laila is a Moroccan-American lawyer. She's the founder of the international law firm and think tank ARPA, the Alliance for Rule of Law and Promotion of an Alternative Dispute Resolution, and also a partner at this conference. Laila is a lecturer at Georgetown University, a commissioner in the National Commission on Dialogue and Civil Society in Morocco, and her fields of expertise are international law, rule of law, and international organizations with emphasis on women's legal empowerment. Thank you very much, Laila. Welcome.
Thank you very much. It's an honor to be here, and I just want to start by saying how this conference came into being. So that's why I think before I say that, I need to again reiterate my thanks to KVINFO, because they're really behind it. They're the driving force behind it. The idea stemmed from a conference actually, and a study that was conducted last year in Morocco, in Rabat. KVINFO, as you may know, works on access to justice for women, and one of their countries of focus is Morocco. So I was called upon to conduct a stock-taking exercise, a study that would take into consideration the implementation of the family law, of the Mudawana in Morocco, since its passage until 2014. So to do a stock-taking exercise over the last decade or so, through basically an assessment of discrepancies in urban Morocco versus rural Morocco, in de jure versus de facto, how the law is written, how the law is implemented through different mechanisms within the framework of access to justice. So we did that, and it was a successful program, and the study was very well received in Morocco. But at the end of the conference, one of the key messages or feedback that we received actually from participants, especially that we did have Moroccan women in the audience, me included, that either helped choose citizenships or were Moroccan women residing abroad, and they came up to us and said, well, what about us? What about us, the Moroccan women that reside abroad, knowing that over 10% of the Moroccan population resides overseas, and the women in the diaspora abroad constitute a large percentage of these Moroccans that reside outside of Morocco. What about us? What is the interplay between the Moroccan family law and the law of the country of residence? So we thought that was a very important question that was under-researched, unfortunately, and even when it was researched, when we did a literature review in the topic, we found that actually it was done at a country level, maybe in France or at the level of Belgium or the countries where there's a large Moroccan population in Europe. However, it was never done at a cross-country, using a cross-country approach. So we thought this is an excellent opportunity, knowing that we have a Moroccan population actually in this country, in Denmark, that it is an interesting starting point that we talk today about actually how does the family law relate to the Moroccan women residing here. And we think that the case study of the Moroccan family law could actually be extrapolated to other family laws, knowing that there are other women of other ethnic backgrounds residing in Denmark, whether from Persian background or Arab background. So we think this is an example that could be replicable or applicable to other communities as well. So this is in a nutshell really the starting point for this idea for the conference. So in terms of what I wanted to do today is, these are just starting presentations. I know that throughout the day today and tomorrow we will have unfolding of thorough discussions, and we will hear firsthand from women residing in different countries in Europe, Denmark, France. We'll have the Spanish experience. I bring the American experience, which I don't think think is that interesting to this audience. And the other thing that we really want to discuss is actually sharing with you a few takeaway messages from the study that was conducted last year. Because I think before our distinguished discussants and speaker talk about the application of the Mudawwana or the law here in Denmark, it is important to actually tell you a little bit about the advances of the Mudawwana in the home country, in Morocco. What are some of the stock-taking barriers that we identified? What are some of the recommendations that we identified? And then move on to discussing the issues that the Moroccan women might be experiencing abroad. So this is, in a nutshell, what I want to discuss. Also, I want to just very briefly frame today's discussion in an international law context, because some of the questions also that come into mind is, okay, so we understand that the Moroccan law is into play, that the law of Denmark comes into play, but what about international law? What about international human rights law? Where does it fit into all of this? Especially in a country like Morocco that revised its constitution in 2011 and recognized the preeminence of international human rights law over national law. So this is also another point that we want to discuss over these next 2 days. So with that, I will kindly ask Fatma to help me with the presentation. You just have to... How do I move? You just have to press here. So when you do it, you go to... I think you can... Just as we can, and then you also can... Thank you, Fatma. So the starting point that I wanted to mention here is, so the study that we did took at the impact of the implementation of the Mudawwana, of the reforms, like I said, in a de jure versus de facto approach in urban and rural Morocco. And we provided an assessment of the social and institutional barriers that were restricting women's ability to exercise their rights fully in Morocco under the family law within the framework of access to justice. The notion of access to justice that was utilized for the study, which, by the way, you can access online through KVINFO's website, is really the notion that is based on three aspects: the normative protections of access to justice, and secondly, the legal empowerment, the ability of the women to seek or invoke legal rights, and then thirdly, the formal or informal institutions that provide legal services to women. So it is in line more or less with the UNDP, with the United Nations notion of access to justice, and other international community organizations. So here you can just see through the slides some of the international conventions, international reports that we drew upon when we wanted to define some of the key terms that we brought up into the study last year. So in terms of the different categories of the study, we talked about the Mudawwana pre-reform, in the pre-reform era, so pre-2004. Then we discussed the advances that were brought upon by the Mudawwana, and then the deficiencies in the Mudawwana. Then we talked about the barriers in urban Morocco versus rural Morocco. And then at the end, we came up with recommendations. In terms of the research methodology, it was mostly just based on a perception analysis, based on the user's perspective, so surveying the women, the Moroccan women in Morocco, about how do they use the Mudawwana, and then also supplementing that with academic research. So for those of you here who are present with us, just so that I know whether I should go fast or not, do you know some of the advances that were brought upon by the Moroccan family law in 2004? No. So are you interested in knowing some of the advances of the Mudawana? So basically the 2004 Mudawana was passed in February 2004, if I'm not mistaken, and it was perceived as a novel piece of legislation, as a progressive piece of legislation, not only in Morocco, but across the Middle East and North Africa region. And there are many advances. Two of them that are really two novel advances in the Mudawana is one, is that the Mudawana redefined the notion of equality in the family unit by challenging the pre-existing notion that people have in the region and in Morocco about the family unit. So the woman is no longer, the woman basically and the spouses, or the wife and the husband are equally responsible for the family unit. They are both joint heads of the family unit. The woman is not required to be fully obedient to her husband. There's this notion of equality between, like I said, the two spouses. The second also advance is that the Moroccan women in civil society, in the civil society movements in the country, had an instrumental role for pushing for these reforms. So here I just wanted to say that basically after the campaigning and the advocacy efforts of these women, the Mudawana materialized, and the king in his speech said in that year, before the Mudawana was reformed, how can society achieve progress while women, who represent half of the nation in Morocco, see their rights violated and suffer as a result of injustice, violence and marginalization? So the efforts came from the top as well, from the king and from the bottom approach, also from the civil society. In terms of the other advances that were brought up, just very briefly, what I can say is the right to self-guardianship, the right to divorce, the right to child custody. Sexual harassment was made punishable by law under the revised Mudawana. The age of marriage for girls was raised from 15 to 18 years of age, and girls were no longer required to have a male guardian to approve their marriages. So these are some of the notable changes. Also, the reforms stipulated that basically the women who are married to non-Moroccans, they can now pass nationality to their offspring, which was not the case before. The Personal Status Code in 2004 did not completely abolish unilateral repudiation of a wife by her husband, but the practice of repudiation was placed under judicial oversight. Additionally, 2 new forms of divorce were introduced. I'm trying to go quickly so I can put this on. I think the other area that I might just briefly touch on is the area of gender-based violence, because that is an issue in Morocco that is a real problem, not just in Morocco but also in other parts in the region. And so in the area of gender-based violence, notable progress was made in that the Mudawana created a system for dealing effectively and efficiently with domestic violence, and there was a rapid increase in the number of women filing domestic violence complaints in the court system. And the good thing about it is that when the reform of the Mudawana came into play, so did the reform of the penal code. So they came hand in hand, and they supported each other, and they empowered the women to be able to file the complaints through the court system. There was also something, and I don't know its equivalent in Danish law, but in US law, it's a restraining order. If you ever heard of a restraining order in the US, so there was basically an introduction in the Mudawana that is equivalent to a restraining order. So that was also a new addition. And there are so many other changes. So for the sake of time, I'm not going to go through all of them, but I would definitely encourage you to look at the study if you are interested. So after taking stock of the advances of the Mudawana, another point that I want to share is taking stock actually of the barriers in the implementation of the Mudawana. So one of the issues is there were still deficiencies in the Mudawwana wording in the code itself that still need to be reinterpreted and reevaluated. And this point was discussed last year in the conference. So, for example, one weakness is that the code's provisions on the joint administration of property acquired during marriage do not include standards for evaluating the wife's contribution in the form of domestic duties, for example. Also, the Mudawwana concentrates mainly on the rights of Moroccan women who are married and not so much on the rights of women who are single or foreign women who are married to Moroccan men and vice versa. So this latter point is extremely important in the number of multicultural marriages that is in the rise in Morocco. Another notable barrier to the implementation of the Mudawwana is the government allocation of resources. One of the key messages that we received from our interviews with governments, with civil society organizations, and with the development community that works on the implementation of the Mudawwana is that implementing it in practice is an issue, especially because there are not enough resources. The government can only do so much in mobilizing resources in urban and rural Morocco. There are issues with infrastructure. There are issues with the courts themselves. For example, in rural parts of the country, accessibility becomes an issue. And so there are a number of constraints that make it hard for the women to seek justice. There's also a paucity of government trainings that are sponsored for judges and public officials, but again, those are very limited in scope because of the limited funding. So scaling up these efforts in all parts of Morocco would certainly benefit the access to justice efforts in the country. In terms of the barrier of the judicial system being the formal mechanism that provides services in Morocco, one aspect that we have analyzed is, does the formal justice system in Morocco for family law provide equitable outcomes for the women? Because it's not just an issue of access to the courts, it's making sure also that we have a just process and an equitable outcome that the women receive. So when we analyze basically the judicial system in the country and how it deals with family law issues, one of the main barriers that we identified is that there are still some practices that might need changing. That, for example, there are still some issues in family law that are still at the judicial discretion of the judge in areas like approval of polygamous marriages or waivers for child marriages and overseeing all divorce proceedings. There's also an issue with the level of public knowledge and understanding of the law. Especially, again, the discrepancies are more apparent in rural Morocco as opposed to urban parts of Morocco because of social attitudes, cultural issues, traditions that our keynote speaker mentioned, because in some parts of Morocco, traditional justice or informal justice is still prevalent. So the women sometimes harbor mistrust of public institutions and feel more at ease in seeking redress from the traditional justice mechanisms that are there. Whether those mechanisms are actually fair, whether they respect fundamental human rights, that is questionable. So that is also one issue that came into play. In terms of, just one last point before we move to the diaspora part, in terms of the recommendations that we came up with in the study, they really span, one, consolidating traditional justice with formal state administered justice. That basically government assistance maybe should be more focused on strengthening the integrity of informal justice systems and its integration with the formal one to become more responsive and more effective in meeting the needs of justice, especially for rural populations. Another area of recommendations was the provision of legal aid services, that maybe we could look at international experiences in the provision of legal aid. So we could look look at maybe Denmark or other countries, US or in Europe, in areas like how do you do legal aid through a multidisciplinary partnership with law schools, with law firms, pro bono work, introducing all these notions or implementing them further at the Morocco level. Another recommendation is the importance of simplifying the legal processes in Morocco, in that there should be a strong move towards simplifying the procedures in all family law matters, as well as promoting a system of alternative dispute resolution. And I think the distinguished judges that are with us today will talk more about these notions of mediation and reconciliation, sulh, and how they are used. But in general, the use of alternative dispute resolution in Morocco is being well received now, and it is being used outside of family law, but we're hoping that mediation especially will be more implemented in the family law sphere, because it will also relieve some of the burden that is on the formal court system. So that was also one recommendation. Another one in terms of the role of the judiciary, a recommendation that actually came up last year at the conference, is the importance of having more women judges in the profession, because that will be an impetus for women, especially again in rural parts of Morocco, to invoke their rights. It will maybe bridge that gap that some Moroccan women might have in terms of social inherent attitudes towards going to court, maybe feeling intimidated by going to court. So having more women in the profession would certainly help in altering these social attitudes. And then lastly, building multidisciplinary partnerships, like I said earlier, from outside the legal community, in terms of thinking about providing legal assistance and counseling and support to Moroccan women throughout the country, by not simply focusing heavily on the profession of law and judiciary, on the bar associations, but also thinking a little bit more outside of the scope of the law and judiciary. So including the universities, the law schools, having paralegals or having law students also involved in these campaigns of legal aid. Also including, of course, social workers. And I'm not saying this is not the case in Morocco, but we're saying this is still at infancy stage in the country, and these efforts really need to be revamped, and more mobilization of efforts nationally, internationally, with the support of the international community is really key. So that's where the support of an international partner like KVINFO comes into play, because it helps us in actually defining the scope of what has been done so far and where do we go from here. So I will end here with the overview of the study. I'm not sure how much time we have, Susano? Couple of minutes. So I think another point that might be of interest to you is international law, because I know that this is a topic that we will be discussing over the next 2 days. So when we think about international law and the family law, one aspect of international law that is relevant, that is personally dear to my heart as an international lawyer, is international human rights law that is applicable to the Mudawwana. So, and that is a few conventions actually. The Mudawwana is in line with CEDAW, with the Convention on the Elimination of Discrimination Against Women. And in 2008, all reservations to CEDAW were lifted by Morocco. So that was a major advance in Morocco as opposed to other countries in the region. So Morocco lifted all these reservations to CEDAW and worked to make sure that all these provisions in CEDAW are actually domesticated and harmonized at the national level. So just to give you a very quick example, one of the reservations that Morocco had at the level of international law is this provision on passing of Moroccan women, passing nationality to her offspring. When Morocco ratified CEDAW and lifted its reservations, it basically made that change and allowed now Moroccan women to pass their nationality to their offspring. Another point that is very important, not only in CEDAW but also in other covenants like the International Covenant on Political and Social Rights, is Article 26, for example, that discusses equality. all these international human rights law conventions bring up the principle of equality as a starting point. Now, in terms of how Morocco is dealing with this principle of equality, Morocco is basically respecting international law in that it follows a tripartite legal framework. The three obligations: the obligation to respect, the obligation to protect, and the obligation to fulfill. To fulfill, because we cannot say that Morocco has implemented equality 100%, because that is, I think, impossible in the whole world. But what Morocco has done is that it is working, the state is working towards fulfilling that obligation. So in 2011, Morocco revised its constitution, and when it revised its constitution, there's a new article in the constitution, Article 9, under fundamental rights, that now stipulates that this principle of equality, and making sure that the state puts it into effect. So one last development that I want to share at the level of international law is that in efforts of advancing equality, Morocco created a committee, Comité de Parité. It's a committee that advances equality between the sexes and works on proposing legislation into that effect. Now, the main issue that we have right now in Morocco is, yes, Morocco has ratified all these conventions. Recently in 2012, Morocco has ratified the optional protocol to CEDAW, which is great, but the main issue we have is these three obligations, of course, are not fully respected. In the case of the family law, the obligation to protect, the normative protections, more or less are there. But the issue is the obligation to fulfill. Because in Morocco, we are still having some barriers, as outlined in the study, that are major impediments to fulfilling this notion of equality. Since we don't have time, I won't touch on diaspora, but I know that we will touch on it later on, and I'll stop right here. Thank you so much for your attention.
Thank you very much, Laila, for this brief and intense overview on the reform track of the legislation on family law in